Thank you, Mr. Chairman. Chief Justice Panganiban, Your Excellencies, Your Honors, ladies and gentlemen. Not long ago, Her Majesty Queen Elizabeth II made a royal visit to my province of Nova Scotia in Canada. The first stop on her itinerary was a town which had recently held local government elections and elected a new mayor, as we call the head of local government at home. Now the mayor, or his worship, was very nervous at receiving so important a guest so early in his political career. And in his nervousness and apprehension, he forgot to put on the beautiful ceremonial chain of office that mayors wear. Her Majesty noted his distress on his presentation and kindly sought to put him at his ease by engaging him in a little conversation. Unfortunately, the topic she chose was to ask him if he did not have a mayoral chain of office. This made a bad situation worse, and the mayor found himself stammering in reply, "Oh yes, ma'am, I do, but I only wear it on important occasions." I tell you that story because if I had a ceremonial chain of office, I would certainly be wearing it today. It is a very great honor, both for myself and for the Commonwealth Judicial Education Institute, to be asked to be with you here to tell you something about the way CJEI, as we call the Commonwealth Judicial Education Institute, the way we develop education programs to assist judges to appropriately render decisions that promote liberty and prosperity. I will look briefly at some of our anti-corruption programming because it is corruption that is a major obstacle and prevents profits from economic success translating into prosperity for the community. I will then look at some new programming relating to legal judicial issues related to the HIV/AIDS pandemic. Before doing this, I need to tell you a little bit about CJEI. I should also like to make a more general comment. It is on the use of the word prosperity in our theme. In the 90s, when multilateral donors got into major funding for judicial reform as a foundation for economic development, much effort was put into trying to find empirical evidence to support the intuitive perception that a strong, independent judiciary was a causal factor in economic development. We didn't get it done. While there were correlations to be found, a high GDP correlates to a strong rule of law, a jurisdiction, while high literacy correlates to a strong rule of law jurisdiction. We could not find the causal factors, empirical evidence that a strong rule of law caused a strong economic development. The substitute, Chief Justice Panganiban, of the word or term prosperity for economic development, redefining economic development in this context to exclude that which limits its profits to an elite group, solves the problem and is a great step forward. In fact, I would think for those of us who toil in the trenches of law reform and judicial reform that it is equal to E equals MC squared. It really is a great achievement. There should be no problem now finding a causal relationship between the rule of law and liberty and prosperity. And I thank you for this breakthrough. Now back to the Commonwealth Judicial Education Institute. Very briefly, we are a volunteer organization of judges. There are no fees to join. Any judges who wishes is a member. It is very non-profit, I regret to tell you, but it is a very interesting occupation for the hundreds and hundreds of judges of the world who participate in our activities. The word Commonwealth is a bit elastic. We are very proud to have as one of our members the Philippines and also Ethiopia and Eritrea. But we are, by definition, a legal charity that is registered as a Commonwealth NGO. Our governance, we're very, very honored to have as patrons the Chief Justices of the countries in which we work, Chief Justice Panganiban, former Chief Justice Hilario de Vida, and the Right Honorable Chief Justice Beverly McLaughlin are three in the room at present. We have a board of directors that is made up of judges and court support staff from around the world. We have an advisory board that is really the heart of the organization, which is made up of the judicial educators in each province with their organizations. Our objectives are to encourage the exchange of human and material resources in judicial education, to promote judicial education nationally, regionally, and internationally, and to be a linkage network among judicial education bodies. And I'm pleased to tell you that with CEDA funding, we are midway in a project to put up on our website all the judicial education material that we can find in the English language and categorized so that it will be easily searched. And as I say, we're most grateful to CEDA for the funding to do that and for the work of our fellows, as we call them, in getting this done in so many countries. Now I'd like to go to a few slides that I've brought. The first one shows how we organize our judicial education material at CJEI. Excuse me. National scheme, but it's actually an acronym pronounced ICE, which is very easy for a Canadian to remember. It actually stands for, and if we can go to the next slide, impartiality or independence or integrity, competence, we go to the next, yes, efficiency, and effectiveness. And I think if you consider it, you will find that those are the qualities of a good judge and also the areas and categories that we need in judicial education. One thing that is interesting is that 3 out of 4 doesn't really get you anywhere. You need them all. It's very hard to decide that you can leave out one of those categories. Can we go, oh, perhaps if we go back to that for a moment. What I'm going to talk about today in the context of judicial decisions that have impact on liberty and prosperity is really the first one, impartiality, in the context of anti-corruption. Competency is substantive and procedural law. Efficiency is just what you think it is, getting the court case flow management, time management. And effectiveness is probably the most important of all for judicial reform, because that's the category where through our program we try to help ourselves to achieve that gap between law and justice. It's that you're a legitimate judiciary, having garnered the support and respect of the community you serve. I'd like to go on now to 2 slides that deal with anti-corruption programming. I like very much to use them, I like them very much, but I like to use them here because they belong to the Supreme Court of the Philippines, and I like a chance to thank them for letting me use them and to illustrate how useful this transfer of judicial education material is. This is a slide that we often use as a basis for programming in integrity. You see, we see the impartial judicial mind, or the basic judicial integrity, surrounded by a lot of bubbles which represent mechanisms to support an environment that best nurtures an impartial judicial mind. And then can we go on to the next one? This one I think is very important in programming for judicial anti-corruption programmings. And I won't go into it in too much detail, but I just want to point out that predator lion called the judiciary, because I think that's a very important initiative that the Institute has been working with over the past few years to assist us to, first of all, clean up our own houses. And we have a special initiative going on led by some of our fellows, as we call people who have gone through our flagship program in Halifax, throughout Asia and Africa, trying to work with the problem in the subordinate judiciary of situations where senior judges instruct the junior judges as to decisions that they would make. And they are able to do that because in so many of our countries, the subordinate judiciary is taken right out of law school, and they are on a graduated career path controlled in many instances by the senior judiciary. So it sets up a difficult situation. Another anti-corruption program that we're working on under the leadership of Justice Khosa of Pakistan, the courts there had a major anti-corruption campaign, and through their disciplinary processes, they did discipline a number of judges who had been taking bribes in exchange for acquittals. And the consequences of that were that the level of convictions rose greatly. Evidently, the judges following the cleansing operation were very much in fear of entering acquittals in the event that they would be suspected of taking bribes. So that was an unexpected result, and one that we're getting leadership from Pakistan in resolving. Now then, I'd like to go to the programming on AIDS and what other social issue could touch more on prosperity and liberty than this dreadful pandemic. To quote from a statement of Stephen Lewis, the UN Special Envoy on HIV/AIDS, there has never been anything like the HIV/AIDS pandemic. Comparisons with the Black Death of the 14th century are wishful thinking. When AIDS has run its course, if it ever runs its course, it will be seen as an annihilating scourge that dwarfs everything that has gone before. What it leaves in its wake in country after country would be hundreds of thousands or even millions of children whose lives are a torment of loneliness, despair, rage, bewilderment, and loss. Furthermore, most of the people affected are in the prime of their working lives. Inspired by this and by the UN 2006 report on HIV/AIDS, and with funding from the World Bank, we brought judges to Halifax, to our headquarters, to our annual Halifax Intensive Study Program on judicial education to support judicial reform. And they worked together to analyze their laws, court cases, and procedures with the view to proposing strategies to address the capacity needs and gender and legal dimensions of HIV/AIDS. This was under the direction of that distinguished Indian legal and judicial scholar, Dr. N.R. Madhava Menon, who assisted the judges in identifying background materials, identifying strategies, and drafting session plans for in-country programming, as well as producing draft budgets for funding proposals based on these session plans. So the judges all went home with a collection of program session plans ready to implement, budgets ready to ask for funding help, and strategies for activities other than the presentation of the judicial education programmings. In the survey of case law and statutes, significant variation was found in how the courts and governments responded to persons with HIV. In a Nigerian case, a woman, a nurse, was barred from the courtroom due to uncertainty over the nature of HIV infection and transmission. She was a nurse who had been dismissed when she was found to be HIV positive. She tried to sue for improper dismissal, her hospital employers. The judge received, hearing the case, received a letter from the lawyers involved saying they were afraid that they would contact HIV, said please not let her in the courtroom. The judge did not let her in the courtroom. The matter was appealed to the Court of Appeals in Nigeria, the second highest court, and it upheld the lower court decision, denying the woman the right to the court. In South Africa, a constitutional court has upheld the right of persons not to be discriminated against in employment situations. In Canada, case law has developed to make criminal charges possible against individuals who fraudulently claim to be HIV negative before entering into what would be consensual sexual relations. And in a Kenyan case, an HIV positive woman was protected from a lower court order compelling her to live in the servant quarters of her own house, even though she had to go on paying the mortgage payments on it. The judges in Halifax also identified the paucity of cases on HIV/AIDS and the need to get more before the courts. The judges identified the following strategies to address the capacity needs in judicial and legal dimensions of HIV/AIDS. Identification and publication of relevant statute and case law, as well as journal article and textbooks. Publication of these identified materials on linkage networks such as our own and many others. The production and publication of manuals on HIV/AIDS for the use of judicial officers and court support staff, written in the vernacular, and the manner of those, and we have two wonderful examples already available for us to copy, the one produced in South Africa for the magistrates, and the one produced in New South Wales for the judicial officers. These manuals are excellent. They discuss the status of the disease globally and within the country. They discuss health medical information on its transmission and treatment protocols. They discuss the impact on women and adolescent girls, details on socio-cultural practices in the region that disempower women and make them more vulnerable. They discuss the jurisprudential issues involved, including a wide-ranging list: human rights, constitutional law, labor law, family relations law, healthcare services and access, criminal law, violence against women, civil rights, evidentiary issues, particularly relating to confidentiality, and the status of legal responses, statutes, and the judicial decisions. The topics of the session plans the judges created, which are available to everyone on our website, are the fundamental principles in dealing with HIV/AIDS disabilities toward a rights-based approach, the implementation of right to life as relating to treatment and care of women with HIV, HIV/AIDS and gender violence, the myth and reality of HIV/AIDS, HIV and the criminal law, non-disclosure of HIV-positive status, sources of HIV/AIDS, including gender violence, survey of particular vulnerabilities of women and children afflicted by HIV/AIDS, legal and judicial remedies, access to the court, evidentiary issues, and rights of the child. That completes my brief journey on the developing of education materials that we are engaged in at the Institute. May I take this advantage in closing my short comments to express my admiration and respect for Justice Herrera and PhilJA, the Philippine Judicial Academy, for the outstanding work they have done nationally and internationally, and also for the support they give to CJEI. Thank you.
Thank you, Judge Sandra Oxner, for such a very informative discourse. And Judge Oxner discussed the importance of judicial education to improve the delivery of judicial services, saw the need of instituting anti-corruption strategies because she feels and believes that corruption hinders and obstructs growth and prosperity in the country. She saw the need to focus on integrity, competence, efficiency, and effectiveness in the administration of justice, and discussed the need for special training on cases involving new legal issues like a litigant who is an AIDS patient. Thank you very much, Judge Afsner. And the last presenter has a Bachelor of Laws degree from the University of San Carlos of Guatemala, a doctorate in civil and procedural law. She rose from the ranks in the Guatemalan judiciary. She started as a clerk, rose from the ranks, and was promoted as Justice President of the Court on Jurisdictional Disputes, founding Justice of the Judicial Board of Discipline, Representative Magistrate of Branch 13 of the Civil and Mercantile Court, Second Magistrate Member of the Court of Administrative Disputes, First Vice Minister of Labor and Social Protection, and Present Magistrate of the Branch 2 of the Civil and Mercantile Court of Appeals. Please welcome Judge Telma Esperanza Aldana of Guatemala.
Buenas tardes.
Good afternoon.
Es un honor formar parte de este foro global.
It is an honor to form part of this forum.
Reciban un cordial saludo del pueblo de Guatemala,
I represent Guatemala,
patria de la señora Rigoberta Menchú,
This is the country of Rigoberta Menchú, Nobel Prize for Peace.
Premio Nobel de la Paz. En el año 1993
In 1993,
se firmó en Guatemala
Guatemala signed
el Acuerdo de Paz
an accord of peace,
firme y duradera
firm and durable,
entre el gobierno
between the government
y el movimiento guerrillero
and the movement, the guerrilla movement,
para dar fin a 30 años de guerra.
to end 30 years of war.
En el año 1985
In 1985,
inició su vigencia
started the effectivity,
la actual Constitución Política de la República,
the fourth political constitution of the Republic,
que marcó el fin
that
de regímenes militares caracterizados por golpe de Estado
ended a military movement
y abrió la posibilidad de una incipiente democracia
and opened the possibility of a better administration,
y hoy día los guatemaltecos
and the Guatemalans today,
tratamos de hacer de la democracia
we try to make of democracy
nuestro estilo de vida.
our lifestyle.